In a world where ancient civilizations often relegated women to mere adjuncts of their families, Bharat, thousands of years ago, crafted a silent revolution, Stridhan. Not a courtesy, not a patriarchal favor, but a binding legal right, deeply entrenched in the fabric of Dharma. Ancient jurists like Manu, Yajnavalkya, and Katyayana declared unequivocally that a woman's property, whether received before marriage, during marriage, or earned by her own skills, was her absolute property, immune from the control of husband, father, or king without her voluntary consent. Stridhan encompassed gifts before the nuptial fire, presents from parents and relatives, earnings from personal labor, and inherited property. Yajnavalkya Smriti, in unambiguous terms, stated that gifts received during marriage or earned independently were to remain a woman's exclusive right. Mitaksha's medieval commentary reinforced that even under her husband's guardianship, a woman's Stridhan remained sovereign, and any unauthorized use warranted restitution and punishment. Fast forward to modern India, and this ancient spirit finds echo in law. The Hindu Succession Act, 1956, under Section 14(1), declares that any property possessed by a Hindu woman, however acquired, becomes her absolute property. The Dowry Prohibition Act, 1961, under Section 6, mandates the return of dowry articles to the woman, while Sections 405 and 406 of the Indian Penal Code criminalize any breach of trust in misappropriating Stridhan. The judiciary has fiercely upheld these protections. In Pratibha Rani v. Suraj Kumar, 1985 Air 628 SC, the Supreme Court affirmed that Stridhan remains the woman's absolute property throughout the marriage, and misappropriation by the husband or his family constitutes a criminal breach of trust. Similarly, in Krishna Bhattacharjee v. Sarthi Chowdhury, 2016, 2 SCC 705, the court ruled that a woman's right to Stridhan survives judicial separation, branding unauthorized retention as a continuing offense, thus preserving her economic dignity irrespective of marital ties. What most lawyers fail to realize is that India enshrined women's economic independence thousands of years before England's Married Women's Property Act of 1882. Bharat did not borrow these ideals from the West, they were conceived here, nurtured here, and lived through the Dharma itself. Stridhan was not a mere acknowledgement of respect, it was a radical assertion of women's sovereign status at a time when the world scarcely recognized them as legal persons. Today, Section 14(1) of the Hindu Succession Act, Section 6 of the Dowry Prohibition Act, and Sections 405 and 406 IPC stand as modern legislative affirmations of this timeless principle. Through judgments like Pratibha Rani and Krishna Bhattacharjee, the Supreme Court has restored Stridhan to the pedestal it once enjoyed under Dharma, not as a borrowed right, but as a reawakening of our ancient jurisprudence. Thus, when someone claims that women's rights in India were imported, remind them, long before the world dreamt of liberty, India had already handed women the right to own, control, and command their destiny. Ancient Bharatiya jurisprudence did not envision women merely as dependents, but as sovereign beings, agents of wealth, dignity, and law. Stridhan is not just an ancient rule, it is a timeless testimony to India's original and proud legacy of women's empowerment.